to this story now, and if you'd like to share your thoughts on it, please do. There's a legal challenge over South Africa's arms exports to the United States. It's before the High Court in Pretoria. The Southern Africa Litigation Centre wants the court to order the suspension or cancellation of export permits, arguing that South Africa's arms control laws require each action where there is a risk of contributing to violations of international law. Although the deadline to oppose the application expired in June, the SALC says the attorneys have received respondents' notice of intention to oppose after issuing a press release on Monday morning. Joining us now is Dr. Atilla Kisla, International Justice Cluster Lead at the Southern Africa Litigation Centre. A very good morning to you, and thank you so much for speaking to us. If I could ask you to just break it down to layman's terms and just tell us the genesis of this matter and why you're headed to the courts.
Thanks so much for having me, and good morning. So the core and foundation of this matter is that in our application we set out four distinct situations in which the US has violated international law in terms of crucial and foundational provisions such as the UN Charter, or threatens to commit war crimes or other crimes. So in our application we go through four distinct situations, like I said, that ranges from lifting a hold on arms exports from the US to Israel, to the US attacks on Iran in June last year, as well as the abduction of the sitting head of state at the time of Venezuela. And we conclude then with the situation that developed in February this year, where with the war on Iran, which situations which have been described by UN experts and other international law experts as violations of not only the UN Charter but also other international law provisions, and that these kind of situations cause developments that, according to the president as well as the UN Secretary General, pose a serious threat to regional and international peace. So on that basis, our application argues that the NCACC, the committee who is in charge of permitting our South Africa's arms exports, has an obligation to either suspend or cancel these permits in question.
In this case, and I'd imagine that every country does it, who do you hold responsible? Your application argues that South Africa has a legal duty to suspend or cancel these export permits. Are you suggesting that with every transaction there needs to be a written commitment by the buyer to expressly, ventilate what the product will be used for?
That's one aspect of it. However, our application speaks directly to the obligation by the National Conventional Arms Control Committee, to the extent that we argue that if there is a country who is buying arms from South Africa that has violated multiple times international law and, as we state in our application, constitutes a threat to international peace and security, that factual pattern triggers the obligation by the NCACC, and in that regard, that the NCACC is not even in a position to make a decision based on discretion, but the law is quite clear here and speaks of must.
So then just take us through then what else that you've asking for, because you're saying that you've received the respondent's notice of intention to oppose after issuing a press release, but I also mentioned in the beginning that that deadline is understood to have passed. So is there still legal standing for that?
So we received yesterday, after we issued our press release in the morning, yesterday afternoon we received the notice of intent to oppose our application. as to why the state respondents filed their notice with such a massive delay, given the seriousness of the matter, is only a question that the respondents can answer in this regard. However, procedurally, this doesn't change what we are asking the court to do. It only changes the path. So what will happen now is that the respondents will now have 15 working days to file their answering affidavit. And instead of an order granted on the unopposed papers, we now get a full hearing on the merits, meaning a full judicial assessment of whether the NCACC has met its obligations under the domestic law. And in that regard, we believe that obtaining a full judgment instead of just an order has the potential to become more impactful.
I mean, for a very long time now, that international criminal law has been seen to be retrospective. Are you attempting to change that by repositioning domestic administrative law as an instrument of atrocity prevention? Is this the thinking behind this?
So the thinking behind this is that domestic law in this context and international law go hand in hand. As international law informs, in this case, the obligations under domestic law. So if we speak about allegations of or acts of aggression, if we look at Iran, if we look at Venezuela, if we look at Iran from last year, with these kind of considerations and international law violations, which have been publicly documented, not only by us but by various UN experts and international law experts. So in that regard, the international law violations inform the factual pattern that's required under the domestic law. And in that regard, it triggers the domestic law obligation of the committee to suspend these permits.
As you say, that they ought to act in tandem, international and domestic law. But if, and without getting too deep into the legal aspects, but I still want to understand, is it more a case of judicializing risk rather than adjudicating guilt? So it's preventative in nature because from where you're sitting, it's not working as it ought to.
Exactly. So what the law prescribes in this context is that if you have a country that constitutes a threat to international peace or security, South Africa should not send any further arms to that country. So it is a way of managing and mitigating the risk by not exporting arms and increasing or supporting further violations of international law, or supporting the country that violates international law in any way, and in this case with arms that can have a serious harm on whether that's civilians, infrastructure, or whatever the case might be in an armed conflict.
Right. We really thank you for your time and appreciate it. Speaking to us about a court case that is before the courts, that there is Dr. Atilla Kisla, who is the International Justice Cluster Lead at the Southern Africa Litigation Centre, and they've approached the High Court in Pretoria to challenge South Africa's arms exports to the United States, saying that they are contributing to human rights violations, particularly of international law.
Madapiri, Pazochitika. Madapiri, Pazochitika.